Yeah, well, thanks for hosting me. Rob, thank you for this idea. I met Rob over pints. He hit me up on Twitter with some questions and said, why don't we just get together and chat over beers a little bit? And then that conversation has led me here tonight. So I didn't raise my hand for having been to 3 previous BitDevs because it's been a long time. I used to come to these meetups in 2017 and 2018 when I was first going down the rabbit hole. And then some stuff transpired in my life that kind of took me out of the rotation for a while, and I just kind of got out of the habit. So I'm glad to be back. I'm a veteran, but it's been a very long time. So I wanted to, as Zach mentioned, I wanted to start with questions. I can talk about this stuff all night, all day. I usually do, but I wanted to really focus on Signal for you guys. So some folks did give me questions through Twitter, so we're going to start there. Some other people gave me some questions just as I was chatting beforehand, so then we're going to go from there. But really, I could do this all night long. So if you guys have questions, or if something I said doesn't make sense, or if you want to go down a different avenue, let's do it. I just want this to be a meaningful conversation for you guys. As Zach mentioned, my background is in estate planning. I am technically a lawyer by background. I'm licensed in Colorado, Wyoming, Alaska, and South Dakota. Part of that is going to get into some of this friendly jurisdictions question, which is something we're going to talk about. Maybe I'll talk a little bit about how I got into Bitcoin in the first place, but this is actually my last month to practice law because the focus that I'm doing now with Bespoke Group as a multifamily office, serving our clients, is taking me really into that much more comprehensive strategy work for the clients I've been privileged enough to serve. So that said, I hope to be able to do a lot more education like this to guys like you and to other attorneys and to other financial advisors and trustees to hopefully elevate the dialogue around how do you do structured planning for an asset that's unusual, like Bitcoin. Because Bitcoin, like a lot of other assets, has some unusual qualities that present some challenges when it comes to planning. So that's what we're going to talk about. I'm just going to probably trying to think exactly which questions I want to start with. I do plan to get to a lot of this. And then the stuff I put in blue is stuff that I thought of that might come up. Let's kind of start with maybe some of the tax consequences. Bitcoin is property. We know it's the most pristine form of property the world has known. I mean, I believe that. I've been into it. Well, let me first give you my background, because that will maybe give me a little bit of credibility in this room of people who don't really know me. As I mentioned, I've been doing estate planning for a long, long time. In 2017, I launched the law practice, Evergreen Legacy Planning. That was March of 2017. A lot of my background before launching that practice was teaching legal strategies to other attorneys. I taught a lot of continuing legal education, and an attorney who had heard me present some of my presentations said, "Hey, will you help me with this case?" It was an individual, it was a family actually, that had a very large estate, over $100 million worth of total wealth. And so I said, yeah, I'll be happy to help out, help you design the strategies. If you need help drafting, we can help draft. Tell me more about it. Well, most of their wealth is in Bitcoin. And I said, I don't know what that means. I mean, so it's like, I don't think I had heard the word in 2017. That's right, I was living under a rock. So while I was right, exactly, Mark, exactly, yeah. So I'm a pretty forward-thinking kind of guy, and I said, well, you know, I don't understand it, but I'm curious, so I want to learn more about this. And so I said, you know, I don't know if I'm going to be able to do much about it because I don't know anything about Bitcoin, but I'll start learning. And then as I started learning, if you are veterans of the space, you remember 2017, this is 3 years post Mt. Gox. This is the hard fork wars, a lot of acrimony in the space. The Silk Road had been taken down, and there's just a lot of negative stuff in the space. And being a lawyer, being trained to be risk averse, but oriented towards being kind of curious and wanting to solve interesting problems, I said, you know, I'm not just going to judge, I'm not going to prejudge this situation until I have a chance to meet the people that I may or may not be able to do business with. And so I met with these folks, and I was fascinated by their story. They had been in Bitcoin since nearly the beginning, and so they had all the stories. They provided some really compelling evidence to me, or kind of some persuasive conversations around why I should take this seriously. And they weren't trying to sell me. They weren't trying to like hardcore orange pill me or anything, but they were saying, don't be closed-minded to it. They gave me some of the resources to look at. And so I started my journey, and I was talking to my business partner, and I said, look, the answer cannot be that there's a family out there with a significant amount of wealth in this asset, and nobody is going to do planning for them. I mean, we know that this is subject to tax if they pass away. We know it's complicated. We know it's valuable. There are all kinds of oracles that can tell us what this is worth at any given time. If we can figure out, if we can understand this asset and how the asset moves, then theoretically, at least, every estate planning strategy we've ever done for conventional assets, that should be on the table with Bitcoin. You should be able to do anything with Bitcoin like you can do with stocks or private equity or real estate or whatever. It's just another asset kind of at its fundamental core. And that was my light bulb moment. And so we did end up doing a lot of really interesting work for these folks. Some strategies based out of Wyoming, which is part of the jurisdictions conversation, some offshore strategies using an island in the Caribbean called Nevis, using another island or a kind of an archipelago off of New Zealand called the Cook Islands, which we can talk a little bit about. And it was all funded with Bitcoin. Pretty cool. And then the client said, hey, can I pay you in Bitcoin? I said, sure, of course. I mean, that's what we're here for. And so February of 2018, I took my first sats in Bitcoin, and we still have those sats now. And then we did a lot more work for those people. And then again, because of my education background, I started teaching to other attorneys about estate planning and Bitcoin. And then more Bitcoin clients came through, and then it kind of took us on the journey where we are now. Along the way, that first Bitcoin client said, look, these are super wealthy people. They've got a lot of needs that go just beyond the legal structuring. They had like some administrative needs. They wanted help with structuring multi-sig. They wanted help with banking relationships. They wanted help with, when they do sell, how can we invest in something that maybe not correlated to the price of Bitcoin? And so before long, we kind of accidentally became a part-time family office for this super wealthy family. And that's where Bespoke came from. That's actually the name, is because it's tailor-made to what these people wanted. They kept asking for things, we kept saying yes, and then that became Bespoke now as a family office. We restructured a few years ago, got SEC registered. We had to decide that we're going to play on the dark side a little bit with the SEC because the regulations are coming. So we are SEC registered, fully regulated, just came through our first review, flying colors, which is nice. So now that's what we do. So I've been in the Bitcoin space increasingly beginning in 2017, fourth quarter to today. I bought Bitcoin every week since then. I've taken fees in Bitcoin. I've bought cars with Bitcoin directly on chain. So I've gifted my children Bitcoin, which is your question, for the holidays. So we'll talk about gift consequences of that. So yeah, I've been in this for a while. So friendly jurisdictions. Why did we choose Wyoming, for example, for some of those strategies early on? Wyoming, as you guys probably know, has been very favorable towards Bitcoin, kind of the broader crypto blockchain world. They were the first jurisdiction in the United States to pass a kind of a stack of statutes that, everything from it's exempt from property tax to allowing banks to help support the custody of it, a whole suite of things. Wyoming also literally invented the limited liability company. Every LLC in the world, every LLC statute in the world, including non-U.S. LLCs, they owe their origin story to 1977 when Wyoming literally invented it. Wyoming has continued to innovate around limited liability companies. And so usually when we're doing, unless there's some compelling reason to the contrary, if we're doing a US domestic limited liability company, it's probably going to go through Wyoming, because Wyoming has a whole lot of different subsets of limited liability companies. It's like the 31 flavors of LLCs that you can have in Wyoming. There's more flexibility with Wyoming LLCs than any other domestic jurisdiction. Wyoming also is a fairly favorable trust jurisdiction. We're going to talk a lot about trusts tonight. We're going to talk about what they are. We're going to talk about different varieties of trusts, from revocable trusts to irrevocable trusts, and then subsets of irrevocable trusts. And your brains will probably be spinning by the time we're done here. And I am happy if this is my first and not my last conversation with this audience, because there's a very deep rabbit hole we could go down around trusts on its own. But Wyoming, within the United States, you basically have two broad categories of trust jurisdictions. You have kind of a more old-fashioned trust jurisdiction that puts a lot of preference on the intent of the person who creates the trust. The person who creates the trust, we often refer to them as the settlor. That's maybe like the first vocabulary word that you'll want to have on the quiz later on. The settlor is usually the legal term for the individual who creates the trust. If I create a trust for the benefit of myself or for the benefit of somebody else, if I created that trust, I am the settlor. The kind of the old school trust kind of way of thinking puts the highest priority on what does the settlor want. Their values are sovereign in this strategy. A more modern and more, dare I say, progressive type of mindset is, it's really not as important what the settlor wants. What do the beneficiaries expect? And so this, I'm not going to get into some of the technical language around it, but there's like this old version that says it's the settlor's choice that we pay attention to. And then there's the more liberal, if you will, version that says, we really don't care what the person who set this up wants. We really care more about what the beneficiaries expect out of this deal. That more modern trend has a tendency to weaken asset protection inside trusts, and has a tendency to undermine the intent of the person who actually built the wealth and created this thing in the first place. So it's probably no surprise that our bias when we're developing strategies is to go towards those jurisdictions that have that more old-fashioned model, because it's really the person who built the wealth, that's the person that hopefully estate planners are really trying to emphasize through a strategy. And I need to put a quick caveat in here. Although I am an attorney, I am probably not your attorney. This is not legal advice. This is educational information. And so don't take any action based off of what you learned tonight, other than learn more. And if you need to talk to an attorney, I'll be happy to help you make connections. So that said, it's also not financial advice, but we're all Bitcoiners here, so take that with a grain of salt.
Cheers, brother.
Yeah.
Who's the one deciding old school versus new school? A judge or?
No, great question. Who decides which jurisdiction you're using? The settlor gets to choose when they're establishing the trust. And this gets us to the freedom to select the jurisdiction that will interpret the terms of the trust. So for example, Wyoming is kind of a hybrid jurisdiction. They adopted some of the new model of the trust laws, but they didn't weaken the asset protection benefits. Nevada, for example, is much more of an old school jurisdiction that places primary value on what the settlor wants. South Dakota is another very good US domestic jurisdiction. Believe it or not, Ohio is. New Hampshire is, Tennessee is. There's a handful of jurisdictions in the United States. There's about 17 or 18 jurisdictions in the US that have preserved that more old-fashioned model to say that really what matters is what the person who sets this up, what they wanted to do. And so whenever you're working with somebody who's going to help you set up one of these structures, you want to help, you want them to at least have a broad enough understanding of various jurisdictions so that they can at least carry on a conversation about this. Yeah.
So will somebody recommend a given jurisdiction based on the strategies that office develops and what your long-term goals would be?
Right, yeah, you will generally select the jurisdiction based off of what your objectives are with the given strategy. And as I kind of alluded to it in my origin story, it's very possible that you will have different strategies for different objectives, and those different strategies will use different jurisdictions.
Okay.
So it's very common. Yeah.
And also, this is kind of like how present the settlor is in the lives of the beneficiaries, as opposed to like somebody who has like ex-wives or is divorced and they don't have like a very clear structure, like no children or something to immediately inherit the wealth. Like there's some kind of deliberation where like you get the separation between like a settlor kind of decision and then like this more kind of creative, like maybe it will be this, maybe it will be that. It doesn't go exactly to the following.
Yes. So if I can kind of unpack that, I mean, I think what you're getting at is that the trust. This kind of gets to one of our flexibility questions that we'll have down here. It's like, yes, there are certain circumstances where Zach and I were talking about this earlier. It's like we don't necessarily know who the ultimate beneficiary of this trust is going to be. How can we build towards flexibility and make sure there's some wiggle room in that structure? We're going to talk about some of those options as well. But in the United States, there are some trust jurisdictions that are very favorable and some that are really not favorable. Colorado's trust law is not very good, to be honest with you. It's more that modern approach, which really weakens the asset protection for the beneficiaries inside the trust. Yes, sir.
What sort of links do you have to have to a jurisdiction? Is there any sort of link required from both the settlor or the beneficiaries or the trustee?
Yeah, it's a really good,
anyone?
really good question. So a settlor can select what jurisdiction is going to govern their trust structure. The trust does have to have what's called minimum contacts, and that is usually, you'll have to have a trustee in your target jurisdiction. For example, if you're going to create a Delaware trust, you have to have a trustee in Delaware. And you have to have property that is titled in the name of the trustee of the trust that's in Delaware. So maybe a fiat account or something like that. You can have Bitcoin or real estate somewhere else in that Delaware trust, for example, but you do have to have minimum contacts in the form of usually a trustee. And maybe not some specific trust property, but those trustees will usually have a bank account, much like the BitDevs account. So it could just be an operating flow-through account, but they have to have something there. LLCs are kind of similar in that the LLC statutes of some jurisdictions are just better than others. Like I said, I'm really favorable on Wyoming. Colorado's is okay, but not super great. And really what we're talking about there primarily gets to the issue of asset protection again. In Wyoming and a handful of other more protective jurisdictions, the protective LLC jurisdictions often line up similar to how the trust jurisdictions line up. But in Wyoming, unless there's some really egregious facts, if a creditor sues the owner of an interest in an LLC, they only get what's called a charging order, which works like a garnishment against distributions. The creditor, if the creditor prevails in court against the owner of the LLC, the creditor of a Wyoming LLC can't go in and foreclose against the LLC interest and pull the assets out of the LLC. Sometimes they can in Colorado. They can in other jurisdictions. They cannot in Wyoming or other protective LLC jurisdictions absent some type of really bad facts. So let's talk a little bit about offshore jurisdictions as well, because this is getting into maybe some of the thinner branches of some estate planning, but I wanted to at least touch on it. I'll get to you in just a second, Adam. I mentioned Nevis earlier. Nevis basically lifted Wyoming's limited liability company statute. So Nevis's LLCs provide a really nice non-U.S. venue for a limited liability company. Can a U.S. person create and own a Nevis limited liability company? Yes, they can. They can own it directly, or they can own it through a trust. That trust could be a U.S.-based trust, or it could be a non-U.S.-based trust. Why would you create a Nevis limited liability company as opposed to a Wyoming limited liability company? The costs of setting them up are probably 2 to 1. For one, it's probably going to cost you at least twice as much to establish a Nevis LLC, and the reporting requirements are going to be a little bit more strenuous because now you're going to have additional IRS filing requirements. The taxes aren't any different, but the reporting requirements are a little bit higher because now you've got a non-U.S. entity. Well, you might do that if you want access, for example, to non-U.S. accounts. Maybe you want to open up accounts in Canada, or you want to open up accounts in Switzerland or Liechtenstein or someplace else. You can't likely do that with a U.S. entity, but you might be able to do that with a non-U.S. entity, especially if it is owned by some other type of structure, like another type of trust. Again, we're getting kind of into the thin branches there, but the other thing there is this issue called the Corporate Transparency Act. This has been a big bee in my bonnet. Boo is right. This has been a bee in my bonnet, and I had probably my best performing thread ever on Twitter was going into the Corporate Transparency Act. So what is it? It's the
government overreach.
It is government overreach. It is an invasion of privacy. I believe it is a violation of the Fourth and 14th Amendment, rights to privacy and rights to due process. It is the law. Sorry.
At the moment.
At the moment. Hopefully it will not be, but it is the law right now. So what does it apply to? Well, first of all, what is it? The Corporate Transparency Act was part of must-pass legislation because it was attached to the Defense Authorization Act of 2020, something like that. Interestingly enough, when the CTA was brought up in committee, it died. It crashed and burned. No member of Congress really wanted to touch it other than the authors. But then it got attached to must-pass legislation. I mean, who in their right mind, who's up for re-election, is going to vote against the Defense Authorization Act? So it gets attached to that, and then Congress shoves this thing right down Americans' throats. And what it does is it creates yet a new federal database underneath the Financial Crimes Enforcement Network, a division within Treasury. And so now it says that the ultimate beneficial owner of any reporting company, that's the important term there, must now register on this new database with what bugs me so much is the Financial Crimes Enforcement Network. Is there an automatic insinuation that there's bad activity taking place in some LLC? So what's a reporting company? It is literally every limited liability company, every other small corporation or whatever that is formed by filing articles with a Secretary of State or with a tribal nation in the United States. There are some carve-outs, but the carve-outs are kind of inconsequential. At least putatively, this was enacted to tamp down on money laundering and funding terrorism, but the biggest opportunities to fund terrorism were left wide open. And unfortunately, what this requires is now you form your Wyoming limited liability company, for example, for the purpose of just managing your own family's wealth. Well, guess what? You are now a reporting company under the Corporate Transparency Act. Also, under the Corporate Transparency Act, what's the purpose of the recording tonight? Just so I can be clear.
To post on YouTube for people who didn't make it.
Okay. Thank you. I need to be careful on what I say then.
Yeah.
Also,
Okay.
maybe repeat questions.
I mean,
Yeah.
If you don't want it to go on YouTube, we can make it private and just share it within the group if you don't want it to be public.
I'll try to be vague but add value. So I'll try to do it that way.
Whatever you think. If at the end of it you're like, I
If
don't
it's
want
way more fun without it, we could also do that.
we can always make it private if at the end of
No, so look, a foreign reporting company This is right in the black letter of the law. This is not anything that we made up. This is the way the law is written. A foreign reporting company is a company, an entity like a company, like an LLC, formed under the laws of a foreign, non-U.S. jurisdiction. And here's the wrinkle. This is what I say with a wink and not going to go into a ton of detail. If that foreign LLC also must also file with a Secretary of State or tribal nation, if it must file, then it is also a reporting company. If it does not have to file, it is not a foreign reporting company. The attentive listener might have picked up the difference. That's as far as I'm going to go on that. So, non-U.S. limited liability company may be an opportunity for people who have certain concerns. And you can do limited liability companies in other jurisdictions, but the one I'm most familiar with, the one I have used most often, has been Nevis because of its origin from Wyoming. Trust jurisdictions, there's a whole lot of other non-U.S. trust jurisdictions. The best one far and away appears to be the Cook Islands. Where the heck are the Cook Islands, somebody might ask. That's a good question. Ask your creditor because they've got to figure out how to sue you there. But in all seriousness, it's an archipelago off of New Zealand. It's way out in the middle of the way South Pacific. Why is the Cook Islands good? Well, they are formerly a British protectorate, so they have English common law, which is where American trust law has its origin story. But they have gone a few steps further than the traditional British common law. They have the shortest statute of limitation on claims that I'm aware of in the world, 2 years. So a creditor must bring a case against the creator or the settlor of a Cook Islands trust. They must bring that case within 2 years of the trust having been established. Okay, that's doable, but what does it take to win that case? Well, first of all, they have to sue where the claim arose. So if that claim arose in Colorado, they have to sue and prevail here. Meanwhile, the clock is ticking in the Cook Islands. They prevail here. Well, the Cook Islands is not going to recognize a judgment from the state of Colorado. So then they have to go to federal court. Well, the Cook Islands is not going to recognize the order from a federal court. Well, what if I take it all the way to the United States Supreme Court? What if I'm the Federal Trade Commission? Or what if I'm a super creditor like that? And I'm going to sue you in federal court, and we're going to take it all the way up to the United States Supreme Court. Well, guess what? The Cook Islands judge doesn't care about what the justices of the Supreme Court say. They say, no, for you to prevail, you first must prevail in your home jurisdiction. Then you have to relitigate it here. Clock is ticking. How are we going to prevail in the Cook Islands? It's not impossible, but they have to hire local counsel who are admitted in the Cook Islands. Well, guess what? All those people live in New Zealand. So now you're going to have to fly counsel to New Zealand, from New Zealand to Cook Islands, and put them up to litigate the case. Guess what? The Cook Islands does not allow contingent fee cases. So the plaintiff has to pay out of pocket as they go. They can't wait for a payback later on. They're coming out of pocket without any assurance that they're going to prevail. Okay, what if they go through all of that and they still lose at the Cook Islands court? Loser pays in the Cook Islands. So a plaintiff who brings a case against a trust in the Cook Islands is paying out of pocket with counsel that is from New Zealand, admitted in Cook Islands. It's a very tiny bar. And if they don't prevail, they get to pay the cost of the defense as well as their cost of prosecuting their initial claim. So that's why we're big fans of the Cook Islands when you start doing some more elaborate type of planning. We're going to talk about asset thresholds in a second, because this is not like democratized level planning. We are, we are in the deep, deep weeds when it comes to this type of structure. Got a question there first, and I'll come up to you.
What are the primary, perhaps non-obvious incentives for either state or a country
Yeah. So why would a jurisdiction make itself a more favorable trust jurisdiction? They simply want the business. They want to attract deposits into trust accounts in their jurisdiction. They become a financial center because, I mean, why else are you going to go to the Cook Islands? You know, so it's a revenue maker for the jurisdiction. Same thing with, I mean, the same thing's true about Wyoming. Why does Wyoming care about having really protective LLC statutes? They just want a lot of LLCs registered there. It's a numbers game for them.
Cities London is funded on Saudi Arabian foreign bank accounts.
Yeah. So you had a comment, and then there's a question back here. You had a question or something?
Yeah, I was just curious of like kind of an example of like a bad actor that you would be protecting yourself against that you would think, I need the Cook Islands.
Yeah. So we're in my last gasp as a practicing attorney. We're wrapping this up this month. I've got a client, hardcore Bitcoiner, in since 2011. Big stacks. They're also a vascular neurosurgeon. So big liability risk. So deep pockets, big liability risks. The consequences of something going sideways could be devastating to the family's wealth. That client is probably going to put $50 million into one of these type of structures. I mean, you know, these scale down below that number. I mean, I know that there are people out there that will try to sell you on a Cook Islands trust and just fund it with a couple $100,000. The juice ain't worth the squeeze, in my opinion. You're looking at putting aside a few $1 million minimum before you're going to do some type of structure that's this complicated. And it's not going to be the total family nut. Let me get to you in just a second. Adam had a question. I forgot to come back to you, Adam.
I was going to say, I wonder if it might be helpful, like that example you just gave. What are examples of why people, whether they're in this group or not, would want to go through setting up an LLC and or a trust?
Yeah, so we're going to talk about these kind of nested strategies. So the question was, why would somebody create a limited liability company that's nested within a type of trust? So I'll get to that question for sure, because that was one of the questions I think you and I talked about, Zach, before this. So I think you had a question, and then we'll get to you in a second.
What about like an S corp that's registered in Delaware? Is there a big difference?
So what about an S corp registered in Delaware? I mean, you're taking advantage of Delaware's corporate statutes. Delaware is a great jurisdiction for corporations. It's also a good jurisdiction for LLCs and for trusts. S corp is just a certain tax election. That's not really going to make a difference from a estate planning type of perspective, other than you're not going to want to have an S corp election on an asset, on a structure that holds assets that have appreciated dramatically in value. Because once the assets appreciate in value, if anybody knows of an asset that might appreciate significantly in value, you probably don't want that in something like an S corporation or an LLC that has been elected to be taxed as an S corporation. Yes, sir.
So the CTA.
Yeah.
How recent is that? Number two, if I already have an LLC, is it in any way grandfathered? Number three, I think I already know the answer to that one.
I think you do too.
What are the reporting requirements and how onerous are they for a small entity where you're basically just creating the LLC as a means to maybe shelter some liability?
Yeah. Yeah, you're not going to like my answers. I mean, so the CTA was passed like a...
in 2021.
2021, okay.
BOI thing that
The beneficial ownership information stuff.
We had to do that for BitDevs.
Yeah.
Super dust.
So yeah, exactly. So it went into it was enacted in 2021. Thank you for that. It then went through this convoluted rulemaking process at Treasury. Those rules were finalized last year and went into effect. The reporting requirements hit January 1 of this year. So now your question about grandfathering, forget about it, because kind of. So we've crossed that Rubicon. We are now in the new reporting regime under the Corporate Transparency Act. So every limited liability company or every reporting company, whether it's an LLC, corporation, whatever, every reporting company now that was in existence before 1/1 of 2024, they have to report, but they don't have to report until the end of the year. Any new entity that is formed now since 1/1 of 2024, they have 90 days to file. And the filing is a new database on, it's called some dumb acronym like BOSS or something like that. And it's a new database, part of FinCEN, and you have to report the beneficial ownership information of who's at the top of the stack. Who owns the LLC, if the LLC is owned by a trust, who's the trustee of the trust, who are the beneficial owners of the trust, like the creators of the trust, any beneficiary who has more than a 25% interest, they have to now be reported. And if you get a new passport, if you move, you have to do it all over again, or you have to update your filings. And I think you have like 30 days to update when there's a change, or maybe it's 90 days, I don't know. But yeah, it's problematic. First hand I saw was here, then you, and then you.
So I'm waiting till December to file. Is that the best way to do it, or could there be possibilities of complications with a big inflow at that time, or like, is that the best route?
Yeah, so the question was, should you wait until the end of the year? If you have a pre-2024 entity, should you wait until the end of the year? I mean, my tendency would be yeah, because you've got the luxury to wait. There's a non-zero chance that the Supreme Court agrees with me and some other people in this room that this is unconstitutional overreach, and it could get reversed. So why dox yourself on a new database if you don't have to? So that's my temptation would be, don't file any earlier than you have to. And if the website crashes when you're going, you've tried and you keep trying, but it's like, I suspect there are gonna be a lot of people making similar decisions like that. Before I get to you, Zach, I had a question here and then there and then here.
So my question was, so my father and I actually own a dispensary, and we have to deal with MED laws and federal regulations all the time. So I guess my question is, does this CTA already bleed into those federal regulations that we already follow, or is that something totally separate we have to do? Yeah,
good question. Is this picked up by other reporting requirements, or is this something new? The bad news is it's something new. Right. The idiocy behind this is that none of these databases talk to each other. And I listened to a presentation given by one of the guys who helped lobby against the CTA. He actually disagrees with me about interpreting the reporting companies, but I'm right, it's in the law. Unfortunately, all the information that you have to give to this new database, the federal government already has it anyway. It's just spread out in a whole bunch of different places. The IRS knows all this information off your tax returns. If you've got whatever your reporting requirements are for dispensaries, the regulators have that information too. But now this is yet another federal database under the Financial Crimes Enforcement Network. It's like, it just creates this onerous burden on small businesses, like operating small businesses like yours, and just families that have created these wealth structures for personal wealth management. I'm going to get you, I think there's one other question, and I don't necessarily want to go down the rabbit hole any further on CTA because we've got a lot of ground I want to cover about estate planning more broadly, but I want to hit your question, and then I think the dentist, I can't remember your name, had a question too. So.
Does the CTA ruin privacy for Wyoming LLCs?
Does it ruin privacy for Wyoming LLCs? It ruins privacy for every LLC. I mean, that's the thing, because the federal this FinCEN database, like all federal databases, by law, are private and secure until they're not. So it's not like just any curiosity seeker can log into this database, but this database has already been attacked. It has already leaked. It's like, all the beneficial ownership information is already kind of out there, but it is the law. But it's like a Wyoming LLC, a Nevada LLC, any US LLC, any reporting company, doesn't make any difference how secure the LLC law is, because if it's a reporting company, the beneficial owner information has to be entered into this database. So if I can take this moment now to maybe pivot away from the CTA, we could go down this rabbit hole all night long. And I know there's a lot of questions around gift tax, estate tax, different types of trusts, sizing the right strategy based off of wealth, based off what your objectives are. So if I can kind of put a bookmark in the CTA, I'm happy to stand around a little bit afterwards if you want to buy me a beer. So what is a trust? I mean, I kind of alluded to this earlier. I'm going to boil it down super simple. A trust is simply a formal agreement to allow somebody else to manage assets on your behalf according to your instructions. That's it. The origin story goes all the way back to the Crusades, when soldiers and knights would go off to battle and they would leave their property in the hands or under the trusteeship, usually of the clergy. And the clergy would manage the property for the men who have marched off to war, and assuming they can somehow hobble back from war, the trustee then returns their property to them. But meanwhile, they've been the caretaker of the property for the landowner. That's where trusts really got their origin story. So you have an owner of property who entrusts their property to some trusted third party who, back in the old days, had their allegiance to God. In the current day, not only do they have their allegiance to God, they're bound by law to exercise fiduciary obligations, but that trustee manages property entrusted to them by the settlor for the benefit of beneficiaries named inside this trust structure. That's what a trust is. Now, there are a whole lot of varieties of trusts. I'm going to talk about them in broad buckets. The fundamental type of trust that probably most people ought to have is called a revocable living trust. It's a trust that you create during your lifetime, primarily for the purpose of privatizing any financial decision-making process if you become incapacitated due to an injury or an illness, or ultimately when you die. Because if you don't have something like that governs the decision-making process, then you're leaving the family under the discretion and direction of the court in a probate type proceeding to then manage your assets according to state law, whatever the law was when you died. So the revocable living trust is kind of table stakes for anybody who has any type of property at all. It really does not discriminate from a perspective of wealth. I mean, frankly, everybody ought to have that kind of trust, in my opinion. Because again, at the end of the day, it's about privatizing the process. Top tip, I think, I started doing this a few years ago, actually about 6 or 7 years ago. We stopped using clients' names in their trusts. It was pretty common back in the day to say, this is the Matt McClintock Living Trust. And then in retrospect, it's like, that's a stupid way to title a trust. So it's like, make up a name. It should be something that's important to you. It could be a landmark, it could be a memory, it could be a character in a movie, whatever. But it's part of kind of creating the first layer of privacy. So if you were to find where my house is for whatever reason, you were to Google that address, you're not going to see my name directly in that. It's going to be in the name of my trust. Yes, I am the trustee of that trust. But as far as my bills are concerned and my property tax bills and all that kind of stuff, it's in the name of my trust. So there's like at least a modicum of privacy just there. That's the base level planning. A revocable trust provides you zero asset protection during your lifetime. Zero. I want to be crystal clear on that, because people say, well, I just want to put my stuff in a trust and that way it'll be asset protected. It's not. If you have the power to control every decision inside that trust, and if you have the power to revoke the trust, if you created the trust, if you're the trustee of the trust, if you're one of the beneficiaries of the trust, you have zero protection through that trust. Because a creditor, if they're successful in a lawsuit, they simply step into your shoes. Your shoes are the trustee of the trust. Your shoes have the power to revoke. Your shoes are a beneficiary of that trust. The creditor has plenty of access, has all access they want to any assets in your revocable living trust. You have zero tax benefit and 0 tax detriment during your lifetime with a revocable living trust for the very same reason. You have not fundamentally changed your relationship with the assets in the trust. You controlled everything going in, you still control everything on the back side of it, you have 0 tax benefit, 0 asset protection. What it does, again, it primarily privatizes the process of decision making in the event when something happens to you. Zach.
Is that pretty much the sole purpose of the living trust then? Is that serving instead of probate?
That's the primary objective, is privacy, to privatize the process, make sure that the people that you have selected, the successor trustee, who would step into your shoes if you become incapacitated or if you die, they have the power to then manage the assets inside the trust. Now, the trust only works if you have the trust that you created and the assets that have a title are titled in the name of the trust. As I mentioned, my house is not in my name, my vehicles are not in my name, my bank accounts, my brokerage accounts, that's not in my name, that's in the name of my revocable trust. So if I become incapacitated, or ultimately when I die, my wife, in my case, is also a trustee of that trust. Nothing has happened to the assets. I died, or I had the stroke, but the trust owns the assets, and now the successor trustee simply manages that privately according to the instructions that I left behind inside that trust. So it saves my wife, or maybe someday my kids, or somebody else, the hassle, the publicity, the uncertainty of going through a judicial process like guardianship, conservatorship, or probate in the event I die. It also creates a structure, and this is going to open up a much deeper conversation around trust frameworks. It creates another structure so that I can attach, or maybe I can build some scaffolding around the assets inside that trust for the benefit of my spouse, maybe for the benefit of my kids or other beneficiaries down the line. I've never been a believer in outright distributions of property to other people. Why? If you were to look at my revocable trust, which you can't because it's private, when I die, that trust continues for the benefit of my wife, but it's in a continuing trust. There's part of that she can do whatever she wants to with, but there's part of it that's just protected for her. She's still the trustee. She can effectively do whatever she wants, but until she pulls the money out of that trust, it's not her property. So if she were to, in a fit of bad judgment, remarry after I'm gone, the assets that are still in the trust don't become part of the new marital property with Mr. Wrong. Since Mr. Right has died, and now she's with Mr. Wrong, the assets in the trust that are left behind are for her benefit. She can control, but she can't bring it in to that new marriage. And why not? So if I distribute that property outright to my wife and she marries Mr. Wrong, not only does it become marital property, what happens if she dies before him? Now he has that property. What happened to my kids? I accidentally disinherited my kids because I didn't think this through. So take it the next generation further, and I'm still in the revocable trust. You can do this type of structuring in any kind of trust framework, but this is how I think about revocable trusts. Let's assume my wife and I are both gone. I've got 2 kids. They're great young women. They make good decisions, but they're still young, and I'm hoping to leave behind something of significant value. That's going to be found money, even if it's not a ton in the real world sense. It's what I've spent my life building. So then if I simply distribute those assets outright through my trust, and I say my kids can withdraw those assets either incrementally, like at certain ages, or all at once, if they have the right to pull those assets out, what happens if my daughters get divorced? Well, now the assets that they pulled out of the trust, they probably have commingled with their husbands, and now that husband has a claim against the inheritance. That's not what I had in mind. What happens if my daughter is in a car wreck and she is at fault and she gets sued? The creditor can step into her shoes. If she has the power to pull the assets out of that trust, or if I didn't even create a trust, I just left it to her outright, the creditor now can just grab those assets and pull them away. If, on the other hand, I said, rather than distribute the assets outright, maybe I trust my children enough to make them the trustees, or at least make them a co-trustee with someone else, according to certain guidelines and provisions inside this trust, but they don't own it. And unless and until they pull the assets out, those assets are now protected from those types of bad outcomes. If they get divorced, those assets are not their assets. Those assets are in a protective trust for their benefit. So I saw the first hand back here.
So in that situation where you're talking about like first thinking of your wife but also your kids, you can wrap, those rules in a way that like your wife could do wife could have certain access to those assets, but not access to like what you wanted your kids to have, right? So like let's say your wife remarries and then she extracts those assets and then leaves nothing for the kids. Like you can wrap in a way that protects assets depending on who it's for.
Yes, so to kind of repeat the question for the recording, yes, you can create different kind of wrappers depending on what it is that you want to accomplish. And the facts are going to be different for a lot of different families. Blended families have unique challenges. For example, maybe he's got kids from a previous marriage, she's got kids from a previous marriage, and maybe they have a kid of their own. Who knows? Those create a whole bunch of different challenges, but all of those things can be tailored in any kind of trust, because really at the end of the day, the trust is a contract. So you can write this contract in a way that contemplates a lot of these types of outcomes. Yes, sir?
How specific or idiosyncratic can you make those terms? So if you're leaving in 2 kids, but you want them only certain kids, if they have grandkids, you require them must have at least 2 grandkids before such and such, must be married for at least 20 years before and such, like how idiosyncratic can you define terms that they can receive the inheritance?
Yeah, it's a good question. So again, for the recording, how idiosyncratic or how granular can you get when it comes to provisions inside a trust? There's a legal answer and there's a practical answer. There are some limits from a legal perspective on what you can do. There are certain restrictions against public that go against public policy. For example, it would not pass. It would be very easy for a beneficiary to challenge a provision in the trust that said you can't marry somebody from a certain religion, something like that. Or if there are, and it's not like a bright line. Every jurisdiction is going to be a little bit different, but there are certain standards you cannot put into a trust that violate public policy. But the other thing, which I think is more worth thinking about, is there are practical limitations on this stuff as well. Because at the end of the day, you're asking somebody, trustee in this case, to execute on this thing. I generally prefer what are called precatory guidelines, which are, this is what I would like to happen. These are my values. This is what I hope to encourage in my beneficiaries, but I give my trustee broad discretion within these overarching guidelines. Because really, as a practical matter, I've been at this game long enough. I have seen strategies go awry when the settlor of a trust tries to get too granular on something like that, because it assumes that you've got a perfect crystal ball today and you know exactly how the next 35, 45 years are going to unfold for the lives of these beneficiaries. I prefer to say something like overarching values statement, giving the trustee broad discretion to exercise their judgment, and then supplement that with something like a letter of wishes that you might update from time to time that is non-binding, but is more informative and instructive to the trustee. So again, you can do that in any type of trust structure. I've been dwelling primarily on the revocable trust because, again, that's a whole rabbit trail on its own, but that's where estate planning really ought to begin, is with a revocable trust. Why not a will? A will is a legally binding document. You can put all kinds of provisions inside of a will. You can even create what are called testamentary trusts that spring forward through your will. So why wouldn't we do that? Well, a will has to go through the probate process in order to be legally valid. Probate simply means to prove the intent of the settlor or the testator, the maker of the will. So the will has no legal effect until a judge admits it to probate and then appoints the executor that you named in there to now execute your wishes through the will. So a will can do a lot of things, but it can't do it privately. Eric, I think you had a question too.
Yeah. So there's, within the realm of avoiding the probate process, keeping everything under private contract, are there any primary, I'm sure that there's, maybe inconsequential exceptions, but are there any primary exceptions where you would avoid a trust structure and you go through an alternative means?
Is there a situation where you might avoid a trust structure and use an alternative strategy? At this layer, I would say no. Now, when we get into the thinner branches of more advanced strategies, there are some solutions that call for things like foundation companies or LLCs or different varieties of trusts. But again, I think when we're talking about, if we're talking about avoiding probate and creating a framework or a form of scaffolding around an inheritance, the trust is, to my knowledge, the only way to go. There are other ways you can avoid probate. You can have things like beneficiary designations. You can have transfer on death certificates. Bitcoin is a bearer asset. You can have a key succession mechanism. You can have a dead man switch. If you're only worried about the mechanical transfer of the assets from a dead person to a living person. There are lots of ways you can do that, but you can't create the framework that has this protective structure. And whether it's a dead man switch, whether it's a beneficiary designation form, whether it's a transfer on death, whether it's a joint tenancy, if I'm a joint tenant on a piece of real estate with my dad and my dad dies and now I inherit that from him, yes, I own the property. We have mechanically transferred the asset to me, but there is no asset protection over those assets. It is still includable in this case, my dad's estate from an estate tax perspective. All we have done is mechanically move the asset. The trust creates the guidelines around how the assets will move and how the assets will be governed as they move. Yeah.
Follow up on that. Within the, so if there's like a dead man switch scenario, is it possible that somebody else within like a perhaps familial relationship could ultimately force the, de facto beneficiary of that Bitcoin into some sort of court process that could potentially lead to garnishment at some point?
I want to make sure I understand the question. Could basically the recipient of the transfer by operation of the dead man switch force the intended beneficiary into a court proceeding somehow? Is that the question?
Right.
Yeah.
Like siblings in a dispute.
Siblings in a dispute, a minor child, something like that, sure. But then the other side of it too is, okay, well, if I'm the recipient of a transfer by operation of a dead man switch, for all intents and purposes, that's my asset. It's a digital bearer asset. There's no document that says what your intent was. It's like, think about it this way. If you've got a vault of analog Bitcoin, you got gold sitting around somewhere, and you transfer the combination of your analog Bitcoin vault to me, and that's all you've done. Said, hey, Matt, here's the combination to my vault. Sweet. I've got a vault full of gold. It's like, that's mine. Because there's nothing that says, there's no title on it that says it's in a trust. There's no instructions that say, certainly no enforceable instructions. No enforceable instructions that say, hey, Matt, give this analog Bitcoin to my mom and manage it for her, or for my siblings, or for my kids, or whatever. It's like, oh, free gold. So that's, again, I want to make sure that what I really want us to land on here is there is a profound difference between mechanically transferring assets and then doing so with a sense of intention so that the people who ultimately receive those assets are set up for success in ways that are protected, private, and tax optimized, ideally. So it's 8:15, and we've covered about 3 things. So long as you guys are getting value out of this, that's fine. But I also want to be mindful. I do want to talk about estate tax, gift tax. Was Mel? Yeah, Mel had a question specifically around what happens if you gift Bitcoin. So I want to talk about that. It's a big question. And so again, I will stick around. I hope to be invited back someday if I haven't worn out my welcome. So let me do a quick rundown of transfer tax. My world has really not primarily centered around income tax. I know a little bit about it. I understand capital gains tax and that kind of stuff. My world has been transfer tax, by which I mean the state and federal gift and estate tax, and there's this little nuance called the generation skipping transfer tax. We're not going to go too far down that road, but just understand at a high level, the federal government would like 40 cents of every dollar you leave behind above a certain threshold. And so fortunately right now it's a very high threshold. The federal gift and estate tax exemption, I will refer to this as the transfer tax exemption. It's currently set at $10 million per US taxpayer plus adjustment for inflation. So the number for 2024 is $13.61 million. So 13,610 for every US taxpayer. My wife and I each have that. So together, my wife and I could pass up to $27.22 million free of gift and estate tax. And every dollar above that is taxed at 40 cents on the dollar. Okay, great. That's a big number right now. Fabulous. So it's right now it's a $10 million number plus adjustment for inflation. This law that we have right now was signed into law as part of the 2017 Tax Act. That 2017 Tax Act doubled the exemption from $5 million per taxpayer to $10 million, plus indexing for inflation. As all federal tax laws are prone to do, it has a built-in expiration date. That law will automatically sunset on 12/31/2025. That's Congress and the president have to do nothing, which is what they're really good at, for the law to revert. So we're going to wake up January 1 of 2026. The exemption has been cut in half just by operation of law. Okay, fine. I'm sorry?
It's the halving date?
Yeah, it is the halving date, I guess. In a way, it is the halving date. It's kind of a different.
It's a bear market year.
Yeah, it's a bear year. So the upshot of that is this is a transfer tax exemption that you can use during your lifetime or at your death. To the extent you don't use it during your lifetime, it is available when you die. But it's kind of a use it or lose it type of thing. So for people who have significant wealth, a lot of the move right now is to proactively take advantage of the estate tax, these transfer tax exemptions, while the numbers are high. If you've got a big stack, and you've got $20 million or $50 million or whatever it is, like you better use your estate tax exemption now, because we know that under the current law, unless Congress acts proactively and unless the president signs whatever Congress does, the estate tax will be the estate tax exemption will be $5 million plus retroactive indexing back to 2017, which is what the law, it reverts back to what the law was when the new law came in. So it is possible through trust structures or through gifting to gift up to $13.61 million free of transfer tax exposure. So if I had it, I could create an irrevocable trust for the benefit of my wife and my children or other beneficiaries if I was so generous. And I could shift up to $13.61 million out of my estate in a protective trust structure. I would claim the use of my $13.61 million exemption. I would have to file a gift tax return. We're going to talk about how do you value Bitcoin for this purpose in a minute. And so I would report the transfer on my gift tax return, and then from that moment forward, all the future appreciation on the assets inside that trust will escape transfer tax. So when I later die, and if Bitcoin has just gone bananas, then all of that growth is outside of my estate. And if I have structured that in a type of trust that is protected and cascades down for many generations, it also avoids this generation skipping tax. The generation skipping tax comes in to say, well, if I have put assets aside for somebody else in a trust for my children, if it is not generation skipping transfer tax exempt, then when my children die or when the trust makes a distribution to my grandchildren, even though it was not in my estate, it's taxed in my kid's estate at whatever the exemption is at that point. So you can create, this is, Zach, I think you had a question about dynasty trusts. This is what a dynasty trust is. So the idea behind a dynasty trust is it's a form of irrevocable trust that I create for the benefit of multiple generations of my descendants. And it's outside of my estate from an estate tax perspective. It is also exempt from generation skipping transfer tax. And if I use a jurisdiction like Wyoming or South Dakota or Nevada or the Cook Islands or something like that, the trust can last for many, many, many generations for the benefit of the people that I have selected, and it will escape that 40% haircut at every generation, so long as the assets remain in that trust. Now, that doesn't mean that the beneficiaries just have to sit there watching the stack just get more and more valuable over time. The trust can provide all kinds of economic benefits to these beneficiaries. It can put them through school. It can help them start businesses. It can own homes that they can enjoy. It can do all kinds of great economic things for the descendants for many, many generations. But so long as the assets have not been distributed out, those assets avoid that 40% haircut at every generation. And so this becomes a massive, massive family, like a family wealth endowment of sorts, if you will.
What happens when these assets are decanted or withdrawn, or the ultimate beneficiary gets some assets? Like, how does that affect the taxation of the assets then? And does it consider the appreciation since the time it went into there, or how do they think about that?
So,
income?
Yeah. So there's several different facets to your question, but when the assets get distributed out to the beneficiaries, it's not usually taxable to the beneficiary at that time, because it's a distribution, usually a distribution of principal from the trust. You can sometimes carry out income to the beneficiaries and have the trust income tax at the beneficiaries' rates instead of inside the trust, so you can get some income tax flexibility. But once the assets are distributed to the beneficiary, the fair market value of that asset is now the beneficiary's property. So let's say that you've got a bunch of Bitcoin or a bunch of real estate or something else sitting inside this trust, and you decide, the trustee decides under the discretion that you've left in the trust, we're going to distribute $5 million worth of Bitcoin or whatever out to the beneficiaries. Now the beneficiaries own that Bitcoin in their name. They can do whatever they want to with it. That is now their asset. Well, if they die, that's on their balance sheet from an estate tax perspective. It is also an asset that a creditor could attach if the beneficiary gets sued and all the other stuff that we talked about why you would create a trust in the first place. But that's now, so now the beneficiary holds that Bitcoin. The Bitcoin goes from 5 million to 10 million. Well, now their balance sheet is worth 10 million because now they own the asset. So that's.
So if you put like one Bitcoin in there today, it's worth 50-something thousand, and 50 years from now, two generations are taking out 0.01 Bitcoin per year. Where's the capital gains tax? Is it ever taxed, and who owes that?
So this capital gains tax question is a really important question. So if I make what's called a completed gift during my lifetime, so I create this irrevocable trust during my lifetime to get the value out of my estate today. The basis for capital gains tax purposes inside that trust is my basis when I put it in there. So if I've got zero basis Bitcoin in there, that zero basis Bitcoin is now inside the trust. So later when the trust trustee sells that Bitcoin, or if the trustee distributes that Bitcoin, the trust has my basis or the beneficiary has my basis. Why? Because I got the value out of my estate to avoid the 40% estate tax instead of the 20% capital gains tax. That's the arbitrage we just played. Now, if on the other hand, the trust I created, maybe it's my revocable trust. The revocable trust is still includable in my estate when I die. The basis in that zero, so if I have zero basis Bitcoin or low basis Bitcoin in my revocable trust, you're right, it gets a step up in basis, it gets a new basis at my date of death. So again, this is part of the kind of the math we have to play in these structures, because, and there's a whole lot of really crazy cool stuff we can do from an estate planning design phase to say, okay, well, there's lots of ways we can arbitrage this inside various strategies, but the idea is you want to have enough of it included in your estate to get a step up in basis, but not so much that's going to be exposed to the 40% estate tax. So that's the balancing act we have to find here.
So ideally, you're leaving under the gift limit in your estate.
Right.
And that gets,
whatever your gift limit is at the time.
That,
right.
We don't know what that would be.
Right.
But in that case, those would get a beneficial step up in basis, which might be more, well, in the tax case, the capital gains would be more preferential for the heirs because they got the step up.
They save 20% on the tax.
But for
right.
anything that's going to be above that amount, it's likely the irrevocable trust to avoid the gift tax and all of that.
Yes, but the so everything that you said is right. The thing you have to bear in mind is when and if we get a new tax law, we could find ourselves with something like we had in 2010, where there was no estate tax, but there was a modified carryover basis rule that said that, look, everything is exempt from the estate tax, but you only get step up in basis on $1.5 million. Everything else is carryover basis. And it just so happens that this was the law in 2010. That's also the year that George Steinbrenner died. And so the Yankees were includable in his estate, subject to no estate tax, but a modified carryover basis rule. And so again, you and I had a conversation beforehand too about how do you build flexibility into these types of irrevocable trust structures. Because to a certain degree, you create an irrevocable trust. By definition, it's kind of irrevocable, right? I mean, it's like you can't kind of reach in and modify the terms yourself. However, there are some creative ways to modify the terms of an irrevocable trust when circumstances have changed. Again, we're getting out into some of the thin branches, but just understand that irrevocable doesn't have to be super scary, for one. There's a lot of different ways you can create irrevocable trusts, a lot of different reasons you would create irrevocable trusts. Some of them deal with getting value out of your estate. Some of them deal with asset protection and privacy. Some of them deal with charitable strategies. There's just a whole host of different types of irrevocable trusts that you might create. But when circumstances change, you can have something like a trust protector who has that you get to appoint that has certain powers to modify the trust under certain conditions and within certain parameters. You can also do, you had mentioned specifically decanting. The thing to bear in mind with decanting, it's just like decanting wine. If you have an irrevocable trust that no longer suits the purposes for which it was created, the trustee, under the laws of most states, and certainly can be further enhanced by the trust agreement itself, can take assets from one trust, create a new trust for the benefit of one of these beneficiaries, and decant or pour assets out of that old trust into the new trust that has more desirable terms to it. That's what decanting is. So again, we're covering a ton of ground. Unfortunately, it's kind of superficial, but I want to get back to the gifting conversation because I promised Mel I would talk about this. So we know that we've got a $13.61 million transfer tax exemption that applies to gifts made during life and or at death. Use it or lose it. There are also certain types of gifts that don't count from a gift tax perspective. The one that most people are aware of are what's called the annual exclusion gifts. That means, again, the law says $10,000. So I could give everybody, $10,000. Again, it's adjusted for inflation. So this year's number is 18, but I could give $18,000 worth of cash, worth of Bitcoin, worth of anything to anybody, including my children, including you guys, which I promise I will not do. And it's not even a reportable gift. I don't have to say anything about it. It's just an exempt gift. So I could gift, and I have, I've gifted Bitcoin to my daughters for the last few Christmases. And so we do it on chain, cold storage, just the way God intended. And then, and my girls are getting a decent little stack for 20-somethings, which is nice. But I don't even have to report that because I keep it under this annual exclusion gift amount. The thing to bear in mind is if you are wealthy and or aggressive in your planning and you find yourself in an uncomfortable conversation with the IRS, they're going to be curious about your annual exclusion gifting. And you say, well, I only gave my kids $18,000 apiece. You give them anything for their birthday? You give me anything for Christmas? Okay, that counts too. So it's $18,000 all in on an annual gift basis. So that's why I might give my kids like $12,000 worth of Bitcoin or $15,000 worth of Bitcoin. Leave a little bit of headroom just in case things get weird. So how do you establish the value of Bitcoin or anything else for that matter for purposes of making a gift? If it is not a reportable gift, if it is clearly under the $18,000 per donee, so the recipient of the gift. I've got 2 kids. I could give them each 18, and it doesn't count. I don't even really have to worry about that. If I were to get audited, I would have to be able to look back at the timestamp and figure out what the value was, looking at oracles across multiple exchanges to see what was the average weighted value of that Bitcoin. And frankly, if we're just dealing with annual exclusion gifts, the IRS is not going to care. But what if we give them more? What if we give them a Bitcoin? Or what if we whole coin our kids for Christmas? So, well, now we're over the $18,000 limit by some amount. We have to have a qualified appraisal. That is a legal term of art. We have to have a qualified appraisal for the value of the asset that we have transferred. So it doesn't matter if it's real estate, if it's Bitcoin, if it's NVIDIA stock, it doesn't make any difference. We have to have a qualified appraisal for the asset that has been transferred. So if I want to either gift outright a whole coin to my kids, or if I want to create an irrevocable trust and make it a completed gift to get the value out of my estate, whatever I put into that thing has to be under a qualified appraisal, which means an appraiser who is qualified creates a report that says that you attach to the gift tax return that says, okay, on such and such a date, Matt gifted these assets, X number of sats or Bitcoins to his recipient here, whether it's a trust or my beneficiaries. Here's the appraisal. There's a company out of Florida that we use a lot for purposes of valuing Bitcoin and other digital assets. It's called Charitable Solutions. They're super cheap. They're like $600 to do one of these qualified appraisals. So it's, at least they were last time we used them, it's not a big deal. Because you've got, Bitcoin is one of the easiest assets to value. It's just a matter of aggregating from various well-known exchanges. Say, okay, here's the exchange price, aggregate them, weighted average, whatever, boom, easy peasy. But you still have to go through that exercise to the extent you have what's called a reportable gift. And a reportable gift is a gift that exceeds some exemption amount. All right, Zach.
You only need to do that if you're doing the annual exemption under the annual, then you don't need to do the
Correct, because that's not a reportable gift.
If the appraiser has this, like, given the nature of Bitcoin, how long is this appraisal good for? Because 5 minutes later, it's no longer that value anymore.
Yeah, so like, for example, if Germany were to start, I don't know, dumping a bunch of seized Bitcoin, 5 minutes later, it's like, holy cow. It's like, okay, well, I don't know the answer to that question, frankly, but you say, okay, you can timestamp I mean, you would timestamp the transfer because you know when it moves. So you timestamp the transfer. You give the appraiser, hey, this is the timestamp. Here's the blockchain. This is where it moved. They're going to look at the pricing at that moment.
So they look at they appraise it
At the time of transfer. They value it at the time of transfer. So
in hindsight of the transfer.
right. Well, it goes to the date of the transfer. So
Is that confirmed on chain, or is that I sent it, and sat in the mempool for,
now you're asking me questions I don't know the answer to. I mean, it's like because honestly, yeah, exactly. So do it on a big scale and find out for us. So it's like look. I mean, we are on the leading edge of this world here because it's like this is the first generation that we're dealing with these issues with something like Bitcoin. I can tell you that the IRS says Bitcoin is property. Convertible virtual currencies are property. It is therefore taxed as property. It is not taxed as currency. It's taxed as property. So it's under the capital gains tax rules like we talked about. It's also under the qualified appraisal rules for purposes of transfer tax. So the same thing happens when I die. So if I pass away, there's gonna be a moment of death that's on my death certificate. You probably better grab the timestamp because like the value of my real estate is not gonna fluctuate that much, or maybe the value of my brokerage is not gonna fluctuate that much. But then if somebody starts moving a bunch of tokens, the value may plummet or the value may skyrocket. Again, I have not seen an estate tax audit come through that has addressed this issue. It's coming, I'm certain it's coming, but I haven't seen it happen yet. But let's say that you die at like 6 o'clock in the morning and then the qualified appraisal looks at a timestamp from like 10 o'clock at night and the value is profoundly different between those two. It's the same day, but 16 hours or whatever, 14 hours has transpired. There could be massive movement. You got to have the question that you should be asking is what is the most defensible value I can put on my return that is going to pass the smell test with the IRS? Because the IRS, and just like all these other regulators, are getting very smart about understanding the blockchain, understanding how transfers work. I mean, it's like the days of being too cute with valuations and stuff like that, those are gone. And so what we would recommend is you take the timestamp and you value it there. And then you shift the burden to your qualified appraiser to then back up the value with their qualified appraisal. Yes?
It kind of seems like in the state, like an inheritance position, if you were your kid, if you could name your kid both the trustee and the beneficiary, that's like God mode in trust estate management. Because at that point, you're the person that is going to get the assets, and you're the person that's distributing the assets.
Yeah, so to kind of sum up, to have a beneficiary who is also serving as trustee of the trust, it is kind of like God mode in a way. You water down some of the asset protection on that. You don't go, it doesn't disappear completely, but you do water down the asset protection. If the beneficiary for whom this trust has been created also has the day-to-day management responsibilities of this, they can pull the assets out anytime they want to. It's their discretion to do that, subject to some provisions, but they're very broad, liberal provisions generally. What we've seen happen a lot is we say, okay, well, maybe if my kids are super savvy with assets, they're mature. In the case of Bitcoin, they understand Bitcoin, they have the kind of ethos around this asset that I respect or whatever. It's like, yeah, I might say, look, if everything is great, my kid can be the trustee of the trust I left behind. But then I say, if my child were to resign, that child has to appoint an independent third party who has a much broader protective framework around it. And so then, at the first sign of trouble, if my daughter, for example, were to be in a car wreck or whatever, her first job ought to be, I'm going to resign as trustee. Because now she could no longer distribute assets to herself, and she has to appoint some independent third party.
In my own experience, I was the executor for my
Yeah.
the bank that was it before to my bank, and then like bringing those under management, which was a very expensive and time-consuming process. And,
Yeah.
like going through the process of hiring appraisers to like value the house and all the other property in the estate. That was also part of my responsibility. But having been named the trustee would have been much more beneficial for me in that sense, because then I wouldn't have to go through all these legal side tricks between me and the bank.
Yeah, so really the comment is kind of talking about the freedom and flexibility that can often come by having the beneficiary serve as their own trustee or step into that trusteeship role. What you described is really common and kind of a more old-fashioned type of structure. My bias has always been to create lots of different mechanisms to remove and replace a trustee down the road, so you don't have to go through all this rigmarole. I don't know the circumstances under which that trust that you're talking about was established, but my bias would generally be, look, if the beneficiaries are otherwise well-adjusted, intelligent people, if you don't want to have them be the trustee for some reason because they either don't understand the assets or they're not mature enough yet or whatever reason, you can have some other third party, but you really ought to let the kids at some point remove and replace that trustee without cause, because at the end of the day, you've established this wealth for the benefit of the people that you care about, and the last thing that you should want to do is send them into some type of judicial process just to get rid of some calcified old trust company down the road. So we often recommend people think through a lot of flexibility and a lot of kind of backdoors in the plans so that we avoid that kind of court outcome you're talking about.
Money spent on an attorney is never money wasted, and you should definitely talk to this guy about planning your estate.
Well, I mean, you should have talked to me before I retired from estate planning practice. But I want to be really mindful of time. It's 8:45 right now, so I want to be mindful.
We can go until 9. So.
Okay, that's cool. I'm fine with it too. I also want to make sure that the questions that came through on Twitter or somebody came to me beforehand. And I think we've covered the questions that came. I saw your hand first, and I'll come over to you, and then I'll come back to you.
Yeah, if we're getting close to the end of the time, you alluded to a month from now things are changing. So what is it that your firm will offer going forward?
Yeah, good question. So what are we doing going forward? What am I as a professional? What are my companies doing going forward? Going into the end of last year, the writing was on the wall that the ETFs were coming through. It was a foregone conclusion. Larry Fink was out there. Everybody else had dusted off their applications, and they all coordinated them to kind of convene around the first couple of weeks of January. We knew that the ETFs were coming through. We also knew it was a halving year. And so we had established a ton of momentum in the multifamily office, which is called Bespoke Group. I've got 3 of my guys here tonight. Jack is one of my guys in Bespoke. Mark is, as well as is Adam Blumberg. I think everybody knows Adam. These guys all work with us as well. But I was talking with my founding partner who helped me form the law practice. He was there when we formed Bespoke at the very beginning as well. And I said, look, there's all kinds of momentum in Bitcoin. We had this debate internally about what the impact of the ETFs would be on the spot price. I won. So I knew there was just going to be a massive retail interest in the ETFs, and a lot of conversation around Bitcoin. And so I was telling my founding partner, I said, look, we need to use 2024 to lean all in on Bespoke, because nobody else is doing comprehensive multifamily office offerings, especially around Bitcoin. And we can't run 2 companies and do either of them justice. Running one of them on its own is a full-time gig, and we were also running a law practice at the same time. And so I told Jonathan, my co-founder, I said, look, one of these things has to give, and it can't be bespoke, because that's just too interesting. We can do everything. This gets to kind of the gist of your question. We can do everything inside Bespoke that we ever did in the law firm, with one exception, and that is the drafting and delivery of legal documents. All of the estate planning strategy, it's not like I have to just wipe my brain and forget everything that I know. We still do comprehensive estate planning design work, education, illustrations, support for all of these strategies. We can facilitate introductions to other attorneys. We can project manage the implementation with those attorneys, because frankly, most estate planning attorneys don't know anything about Bitcoin. And I mean, part of this pivot, I think, helps us address that shortage, because we'll no longer be seen as competition to other estate planning attorneys. We're a family office that is serving family office clients. We just happen to have deep chops when it comes to Bitcoin and complex planning. So in addition to all the strategy work that we will do, once all these trusts, all these plates are spinning, all these various LLCs and irrevocable trusts all over, once these things are going, you don't just put them on a shelf. They have to keep running. Somebody's got to manage this stuff day to day. Somebody's got to see that the reporting gets done. Somebody's got to hold the trustees accountable. Somebody's got to coordinate things like tax returns, coordinate things like valuations. That's part of what Bespoke does as a full stack family office for our clients. We're a multi-family office, not a single family office. So we serve a lot of accredited investors in this space. In addition to the estate planning work that we do that I'm describing in the kind of the fiduciary relationship management, we're also SEC registered. So a lot of Bitcoiners, when things are frothy, or maybe they just want other assets that are not Bitcoin, we help them develop portfolios that express their worldview. Bitcoiners have a certain worldview, and we help them express that through public markets, private markets, domestic or internationally. A lot of this may come as a surprise to people in this room, but some Bitcoiners, believe it or not, are concerned about the trajectory of the US dollar. Shocking, but it's true. I know. And so part of what we can do, because of our relationships overseas and because we're SEC registered, we can facilitate non-US banking for our clients, which gets them into things like the Swiss franc or the Norwegian krone or the Singapore dollar or other currencies that are fiat currencies that are harder than the US dollar, as just a hedge. It's just a hedging tool. Sometimes our clients want securities that are denominated in the franc, for example. Maybe they want their dividends to earn in francs instead of dollars, because when we started this project, I think it was like a decade ago, we started paying attention to some of this stuff kind of more broadly in the markets. I think the US dollar was trading like $1 to 0.8 francs. The dollar is now trading to 4 francs. So the value of the dollar has eroded very quickly against the franc in a fairly short period of time. I mean, my timing may be off, but the numbers are right. It's gone from $1 to 0.8 francs to to $4 for the franc. Sorry, I had that backwards. So the dollar has lost 4 times its value against the franc. It's probably not going to change for the foreseeable future. So that's what we do. We kind of like to say that we're a multifamily office that's much more like a old world European type family office, because we don't have products to sell. We don't have investment vehicles. I'm not going to sell anybody a fund. We don't take a 2 and 20 on anything. It's like we don't have financial products to sell. We sell ourselves. We sell our strategies. We sell our services. And if we add value, that's great. If not, that's fine too. So that's the. Does that answer the question? I mean.
You're a multi-family office.
We are a multifamily office, but at least when I hear multifamily office in the traditional sense in the United States, I think of an RIA that has been super successful, and now they bundle a bunch of investment vehicles into an SPV. That ain't us. We don't have anything like that. I think you had a question.
Yeah, I was curious where to direct, like if we had a state attorney friends or family to learn more. Is your company a resource for that? Or what's the best, like people we care about that are in that world?
Yeah, how do you orange pill other attorneys or other fiduciaries?
Or like open-minded people, what's the best place to direct them to learn more? Like, I know a guy that I might have help me, and how do I get him where I feel confident that he's knowledgeable enough to get my inheritance where I want to go?
I mean, I think that's the $21 million question. There are a few answers to that. One of them is sitting in the back of the room. Adam Blumberg has been a great educator in this space through his company Interaxis. He's done a ton of education around primarily financial advisors, but a lot of that also extends to trustees, other fiduciaries, and that's applicable for estate planning attorneys as well. Fortunately, there is a growing number of continuing education presentations that are out there that we have nothing to do with that are talking about crypto and kind of this new asset class. They're probably not really Bitcoin specific, but they're at least opening people to this idea of digital bearer assets that have monetary value and how you plan around that. I've talked to Mark Mariah about this a lot as well. In a post legal practice world, one of the things that I want to do in the next, in the coming year or two is I want to create a body of educational content around this, just in a library that we host on our website. Ideally, it's free of charge, just to say, for stuff like this. How do you do a trust when you have to contemplate an asset like Bitcoin? It's, the TLDR on that is, it ain't that much different, but it is different enough that you got to do it right. There are things like, for example, Bitcoin being highly volatile, as we've talked about. The volatility seems like it's come out a bit, but it's still volatile, and we hope it's volatile in the positive direction for a long time. Bitcoiners also are ideologues when it comes to our assets like this, and so often Bitcoin represents a disproportionate amount of the wealth that we have built. Am I maybe touching a nerve here, Zach? It's like
The correct amount.
Yeah, the correct amount, exactly. But when it becomes whether it's disproportionate or correct is a question of degrees, I suppose. But as a practical matter, anytime a trustee is responsible for managing assets for the benefit of other beneficiaries, if the assets are heavy weighted in anything, then unless you've designed the estate plan carefully, the trustee is under what's called the prudent investor rule, which means they can't hold any heavily concentrated position in anything, whether it's volatile or not. So it's like, it could be like 98% real estate. Well, that's not really going to work, so they're going to have to diversify out of some of that kind of stuff. So one of the things that we do with the clients that we serve now, and part of what I will educate around in the future, is modifying or waiving this prudent investor rule. Because under the prudent investor rule, the trustee has a duty to diversify trust assets. Well, that runs counter to a lot of Bitcoiners' ethos. Yeah, that's a fiat thing, but you got to realize, this is a conversation I was having beforehand. Remember that we're still Bitcoiners living in a fiat world. These laws, these trust laws that we've been talking about all night long, these things came about in the 1600s, 1700s, 1800s, 1900s. We're dealing with a 21st century asset under 17th and 18th and 19th century laws. So the world that we want to build is not the world that we have right now. And so we have to take the structures that we have, that the law recognizes, and then carefully select the jurisdictions and then modify where we can to get the outcomes that we're looking for.
Is this the prudent man? Is this as simple as putting a provision in the trust that says like Bitcoin is exempt from this
It can be, or it can be waived altogether. You can modify the prudent investor rule. You can exempt your trustee from the prudent investor rule. But this gets all the way back to friendly jurisdictions, because different jurisdictions have different amounts by which you can modify these default rules. We also like to do things like bake in provisions to say once the Bitcoin exceeds a certain dollar threshold in fiat-denominated terms, the trustee better have it in multi-sig or some type of more secure signature structure. And because we try to think in terms of generations, not in terms of years, any dollar amount that we say, it's going to be pegged to the cost of living adjustment based on where the trust was created. So that way, like $2 million or $10 million today may not be that much money if Bitcoin's going like this and the dollar is going like that, yeah, right.
Bitcoin also being classified as like personal property. There was like a collection of gold and silver when I sold my estate, and dealing with that and who got what was also a part of the management process.
Bitcoin is a form of personal property, but unless it is something like an ordinal that is unique in its format, I don't want to go down that rabbit hole necessarily, but it's like there's a difference between an ounce of unmarked gold and a Krugerrand, for example. One might be more valuable than the other just because of what's imprinted on it. So it's like, I mean, in an ordinary sense, every Bitcoin is the same value as any other Bitcoin, but if we go down some other rabbit hole, then somebody would make the case that some Bitcoins, that all animals are equal, but some are more equal than others, to borrow a George Orwell term. I want to be mindful of time. It's 5 till 9. This has been a real treat for me. I hope this has been valuable. Thank you, Zach and the BitDev guys for hosting me. I'm around. I'm in town. I live up in Evergreen. A lot of the people here know me anyway. So as Coach Prime would say, I ain't hard to find. So thank you very much, guys. Appreciate it.